Hands up if you're a landlord or an aspiring landlord. I've got good news, you're in the right room. If you didn't put your hand up, you're either confused, a little bit shy, or you're expecting the next Corn Exchange Cinema, in which case you might be a little bit disappointed. So, over the next hour, we're going to be talking to you about the Renters' Rights Act and what is critically going to affect you as landlords going forwards, because there is an awful lot of change coming your way. How many of you have actually looked at the Renters' Rights Act in any detail? That's a reassuring number. Well done, you. How many of you understand it? Yeah, not quite so many hands going up. Okay, a few. That's good to see. All right, so you have one job today. And your one job today is to make sure you don't leave here with any unasked questions. Because this is your opportunity to make sure you do understand it and you do understand your obligations. Because guess what, folks? We've got just over 2 weeks before this comes in. It's the biggest change affecting the private rental sector in over 30 years. So it's really simple. Don't leave with any unasked questions. Those of you who have been to our seminars or our webinars before, firstly, thank you for coming back again. But also, in previous editions, we've been talking about what we think is going to happen. There's been a certain amount of grey area, a certain amount of conjecture. What we're talking about now is fact. It's coming in 2 weeks' time. Now, when I say fact, 99% of the way there. There's still some guidance notes and things creeping out even now, just 2 weeks away. But this is what is happening, and this is what's largely happening over the next 2 weeks. In terms of the format, firstly, we will send you a copy of the slides at some point in the not too distant future after tonight, and also a recording if that works as well, you'll get back to. And of course you can reply to that email with any questions that you failed to ask tonight, but please don't do that, ask them tonight if you do. And we will have a formal question and answer at the end, so any generic questions about what we've spoken about, please do ask them, because somebody else is probably thinking the same thing. If you've got specific questions, then the team will be available afterwards, and please join us for a glass of wine and a drink, and you can come and talk to us about any of those specific queries, because everybody's situation is unique. Please do come and have a chat with us informally afterwards as well. That's an opportunity for that. And on the back of the guide that you've been given, there is a QR code. And that QR code, if you scan it, don't do it now, please listen to what we're saying, but if you scan that later, that will enable you to book in a free 15-minute consultation with one of our qualified letting experts if you've got any questions about your property as well. So there's different methods there of getting in touch with us. So without further ado, we're going to be talking about all of this. There's an awful lot to cover. And those that have been to these things before, quite often we have some external speakers as well. We don't tonight. And that is because there is so much we need to convey to you because it is time critical at this stage. So we're talking about the timeframes of what's going on with the Renters' Rights Act, what the penalties are if you get it wrong, and perhaps more importantly, what practical steps you can take now to ensure that you are compliant going forwards. We'll be covering the key items about what's going to change with tenancies and how you obtain possession of your property, the steps you can take to manage your property and your tenancy. And then we will step away briefly from the Renters' Rights Act to cover essential items like making tax digital, very briefly, changes to energy efficiency standards, and then if we've got time, I will dive into, very quickly, the local sales and lettings market, just to give you a feel for what's happening, because let's be honest, most of what you read in the press is A, doom and gloom, and B, not specific to our local property market. So where are we now? Well, the first part of the Renters' Rights Act has already started, because on the 27th of December, a slightly late Christmas present from the Department of Communities, Housing and Local Government, they are now allow local housing officers to come into estate agency businesses, properties they suspect of being rented, and to seize documents and any IT equipment if they believe there is cause for an investigation. And they can do that now without a warrant, and that is new. And in fact, local governments have just been, or local authorities have just been given a total of £60 million across the 317 authorities that they can spend to ensure that their enforcement teams are up to speed, to help them go out and look for areas of mismanagement and poorly managed properties. So this is absolutely going to be hot off the press coming from the 1st of May. The other thing that's already out, and I was going to print off a copy to hold up, but I'll be honest, it's not very interesting, but the Renters' Rights Act information sheet is out. It was issued on the 20th of March, and actually one thing you have to do if you have a rental property now is to ensure that that is issued to all of your tenants by the end of May. So by the 31st of May, that document has to be issued to every tenant that you have. Failure to do that is a £7,000 fine, and of course you have to be able to evidence going forwards that you have done that as well. And you can't just send them a link, you have to send them the actual document. It can be a PDF if you want to do it electronically, but you can't send a link, you have to send the actual document. And I wasn't going to mention this, but I was asked a question on the way in, so I will. If there's anybody out there with an old, handshake and a nod and a wink type for short tenancy at the moment, instead of that, or as well as that, you have to issue the key contract terms. You can no longer have a verbal agreement contract from the 1st of May. So by the 31st of May, if you've got a really old-fashioned, down the pub, nod and a wink tenancy agreement, you have to write down the core terms and issue those by the 31st of May. That is in now. So, what's coming up very soon, in just a couple of weeks' time? All the key core elements of the Renters' Rights Act, or the key ones that we've spoken about before, come into effect on the 1st of May. So no longer can you issue a Section 21 notice. Every tenancy will change from being a short-haul tenancy to a short periodic tenancy. There'll be a reform of the possession grounds, and instead of that Section 21, we'll be issuing Section 8. Don't worry, we're going to go into some of these in more detail as we go through the evening. The only way to increase rents from this point forward will be via a Section 13 notice. Rental bidding, i.e. overpaying from the asking rent, will be outlawed. And likewise, payment in advance will be something that can no longer be taken by landlords. Discrimination, and we're talking here largely about saying, rents with not allowing children or not allowing those in receipt of benefits. Again, any advertising along those lines, completely forbidden. Landlords cannot reasonably refuse pets in rental properties. And we'll go into that in more detail as well, because that's always a really contentious issue. And as I've already alluded to, there'll be much stronger enforcement, and the penalties will be increasing as well. So it sounds pretty much doom and gloom, doesn't it? But it's not all bad. And actually, some of the things will be improved. So if you want to get your property back because you want to sell it, because you want to move back in, or a member of your family wants to move back in, because the tenant is not paying their rent, because there is antisocial behaviour, or because you need to refurbish the property, all of those things are still allowed. And in fact, there are additional grounds for getting back. Just the mechanism by which you do it has changed, and you have to use a Section 8 notice to do that. Now, in issuing these notices, those notice periods have also changed, and as a rule of thumb, they pretty much doubled. So a tenant must give 2 months' notice, and as a landlord to a tenant, you have to give 4 months' notice. So, if you agree a tenancy on the 1st of May, and you then decide, I want to sell my property, actually, bearing in mind you've got to give them 4 months' notice, then they are protected in that tenancy for 12 months. So at month 8, you issue them 4 months' notice, and that is their 12-month minimum period. So if you issue a new tenancy or renew a tenancy now, 8 plus 4, 12 months, it's 12 months' notice from granting a new tenancy. If it's a tenancy that rolls on, then you can give that 4 months' notice at any point, but they must have been there by the time they leave for a minimum of 12 months. Now, those of you who are listening carefully might have picked up on the fact that a tenant only gives 2 months' notice. That has to be in line with the rent due date. So if they turn around on day 1 of their tenancy and went, that was a bad idea, I no longer want to rent this house, they can give 2 months' notice right at the start, but of course it has to be in line with the rental due date. So actually the shortest tenancy is 3 months in practice. Now don't panic, not every tenant's going to be wanting a 3-month tenancy, and we must remember that this has been in place in Scotland for some time now. There hasn't been a reduction in average tenancy length. In fact, we've seen quite the reverse. We've got offices in our network who are up in Scotland, and they've seen their average tenancy length increase. So don't panic on that front, but it is a slim possibility, and we need to be aware of that. So that's the protected periods covered, and a little bit about giving notice, which I say is via a Section 8 procedure. And those Section 8 grounds have been expanded. If you do decide to sell your property, the Section 8 notice is actually the nuclear option. You don't want to issue that unless you absolutely have to. And the reason for that is very simple. If you issue a Section 8 notice on the grounds that you want to sell the property, or indeed to move back in or move a member of your family in, then there is a protected period there for tenants, which means you cannot subsequently change your mind and re-let that property for 12 months. So in effect, what you're saying is, if I say I'm going to sell my tenant, I'm going to sell the house, and so I want them to leave, and I've told them that formally via a Section 8 notice, if 3 months into the process, something crazy goes on with the world, I mean, how unrealistic is that, right? Something crazy happens, and the market dive bombs, and you can't sell it, but you can't move another tenant in for another 9 months, as in 3 months plus 9 months. You cannot re-let that property for 12 months, because the fine is, guess what? It starts at £7,000 and rises to £40,000. So you are baking in, potentially, a 12-month void period if you issue a Section 8 notice to sell or to move back in, and don't subsequently sell or move back in. Does that make sense? So it's really critical. So if you're in that situation, speak to your agent and talk about what other options there are, because it might be that the tenant's happy for now, or we try and sell to another landlord investor without issuing notice, because if it's a good, well-managed property, achieving the right rent, then somebody else, another investor, might well want to buy it if the yield is right. And that is much better to go down that route than it is to go down the lengthy legal process of getting the tenant out and then finding you can't sell the property, because then you're between a rock and a hard place, because you cannot re-let it. So that is a bit of a whistle-stop tour through possession and notices, and what I've done at the end of the presentation and what you'll be sent will be the full list of all the different Section 8 grounds, but the main ones I've said are still there. If you want to sell it, want to move back in, there's antisocial behaviour, you need to refurbish the property, all of those remain valid grounds. Now I'm going to hand you over to Joy and Katie, who are going to take you into a lot more detail about things that you need to understand for the renter's rights.
If anybody wants to come and grab a seat whilst we're setting up, there are a few seats at the back if you want to sit down. Okay. Our voice is on as well as Brendan, so we're going to use some mics.
Hopefully, yeah, that's picking up. Perfect. Okay. So I'm Katie, I head up the property management team.
And I'm Joy, and I run the office here in Whitney, and between us, Katie and I have over 30 years experience of letting and managing property in West Oxfordshire. We literally live, breathe, we dream lettings and property management. We need to get some life skills. So hopefully in the next sort of 20 minutes, we're going to tell you a little bit more detail about what Brendan's summarised earlier. Brace, here we go.
So the practicalities of it. What happens on the 1st of May to your current tenancy agreement? So at the moment you're likely to have an AST, so an assured short hold tenancy, and come the 1st of May, they will all transfer into what's called now assured periodic tenancies, so APTs for short. The fixed term of your tenancy will disappear along with any of your rent review clauses, but other special clauses that you have in that tenancy will still count. So if you've got special clauses for the gardening, pets, anything, like you put energy efficient light bulbs in there and the tenants must make sure they're there when EPCs are done, anything like that will still count. But the physical term and the rent review clauses are nullified and all tenants go onto a periodic tenancy. So that means from the 1st of May, all tenants are on a 2-month periodic tenancy. You do not have to reissue your tenancy. You will hopefully have issued the government guideline, but you don't have to reissue your tenancy. It will be something that naturally happens.
So if my tenant has just signed a new agreement, that doesn't count?
All of the clauses other than the term will count, but the term will not count, no.
Okay, right. So linking on to what Brendan spoke about earlier, it's this importance of making sure that if you're renting a property to a family member or a friend and you're taking rent, that you do have excuse me, a written agreement in place. It's got to have all the basic terms, but what you've also got to have there is where notice can be issued by the tenant to you or vice versa. And you'll see how important that is later on, but you must have that in place by the 31st of May and depending on if it's a new agreement or not, issue the additional documentation as well.
So the biggest question that I have at the moment is how will I increase my rent after the 1st of May? And as Brendan alluded to, the simple answer is a Section 13. Now with that, the way to look at a Section 13 is that it needs to be issued on the date that your tenant comes into their annual anniversary, and the notice period of that has changed and it's increased from 1 month to 2 months notice. You need to ensure that the way your tenant has authorised you to correspond with them, which in our Parker's tenancy agreement is via email, and that would be the way that you correspond with them with these formal notices. So you need to check your tenancy agreement, and if it says that you will correspond with them via post, then you will need to post or hand deliver a Section 13. All of ours are delivered by email. And then the most important part of this is that when you increase your rent via a Section 13, the tenants are now going to have the option to use the first tier tribunal. So you must make sure that you're increasing it in line with market value rent and not more, and that most importantly you can evidence that. So you will need a market rent report that shows you have a 2-bed property on Whitney High Street and these rent for £1,200 and you're trying to increase your rent to £1,200. And it has to show it on the specific date that you're issuing your Section 13. So not last month, not what's going to happen in the future or what happened last year. In that exact moment, you were being very fair with your increase in rent. If the tenant doesn't agree with your Section 13, they will have the opportunity to go to the first tier tribunal. Now last year, we were stood up here saying, if you were a tenant, you would use the first tier tribunal because it was free, and why wouldn't you? It delays your rent increase, and luckily the government have cottoned onto that, and there is now a £47 fee for a tenant to use the first tier tribunal. So if you're being a fair landlord and you're increasing in line with market value rents and you can prove that, you're likely to be able to gain that rent. If your tenant goes to the first tier tribunal, what will happen is they will ask you for your Section 13 and your market evidence report to show that you were being fair, and what they agree is fair is final decision. Previously, they were able to say, well actually Mr Landlord, you were being too fair and you should be getting £1,400, not £1,200. They're now saying they will go to the maximum of what you've asked for. So if you've asked for £1,200 and they agree with you, that is what you will get. Now, of course, if you're managed or on Rent Receipt Plus service with us, that's what I do for you, and I cover all of those market rent reports. And we let 1 in 4 properties in West Oxfordshire. So we are absolutely the experts in what your property should be achieving and how we go about that.
Could you perhaps negotiate a rent? So if you issued your Section 13 first, could you perhaps have a conversation with your tenant and agree something before they went to the first tier tribunal?
Yeah, they might come back to you and say, Mr Landlord, I just can't afford that increase. This is what I can afford. What I would recommend, if you do manually agree that with your tenant, is that you confirm that in writing, or even better, you reissue your Section 13 with that new amount on there. But the idea of all of this regulations and changes in the law is to keep landlords and tenants out of, where possible, first tier tribunals, and the courts and try and have some negotiations between yourselves to sort everything out.
Yeah, so you've really got to know your stuff and be able to evidence it. Brilliant. Okay, so it wouldn't be a talk on renters' rights without talking about pets. Katie, a few things have changed since we were up here last year, so can you just quickly go through those for us?
Yeah, sure. So it's still a case-by-case basis. We've had a little bit more information on what is the definition of a pet versus the definition of an animal. So a pet, a person will have a personal interest in, will provide them with companionship, or might have an ornamental purpose. Whereas an animal is likely to not be domesticated and to be kept outside. There's some further guidance with regards to assistance pets. So assistant pets must be certified and trained animals. Now, if your tenant asks for an assistant pet, this is where you're going to need to be really careful, because if you do not allow or you refuse that pet, you will fall foul of two laws there. So you've got the Equality Act 2010, where a person who needs a disability or assistance pet has asked for one and you are not allowing them to have that. Then you've also got the Renters' Rights Act law with the pets. So permission cannot be unreasonably withheld. If your tenant would like a pet, they need to put that in writing to you, and they must describe the type of pet they want. So you might get a request that says, "Dear Mr. Landlord, I'd like a dog. It's a 2-year-old cockapoo. Please can I have permission?" So it must state what type of pet, what breed of pet it is, and also the age. So there's no wishy-washy, I said yes to a dog and I thought it was a cockapoo and it's actually an Alsatian, or I said yes to pets and now they've got 10 Labradors in there. So it's really quite clear in that email what they're asking for. As a landlord, you have 28 days to respond to that tenant formally. If you need further information, so you might need more information from your tenant, or you might need information or permission from your superior lease, then you can extend that deadline together mutually. If a landlord fails to comply with this law, so they don't reply in 28 days, or refuse permission and the tenant feels that that was unfair, the tenant again can apply to the first tier tribunal and have that looked at by the authorities. Now, good reasons for refusal still stand similar to what I explained last year. So if you've got an allergy as a landlord, that's a good enough excuse for a refusal, reason for a refusal. The suitability of the property and the number of pets. An interesting one that we heard over the last couple of months was also around the type of pet. So if you have a property that has an issue with mould and condensation in there, and you keep an eye on how many people you have in there, how you dry laundry and things, if your tenant asked for a pet fish, you could refuse that on the basis that a fish tank is going to add to the issue of mould and condensation within that property. Similarly, any pets that are on the dangerous breeding list, so all of these XL bullies and things like that at the moment, if they're on that list, you can refuse them on that basis. If you give permission for your tenant to have a pet, you must make sure that you cover that fully with a clause in your tenancy agreement, with the type, age, breed of pet, and what you expect the tenants to do to the property when they vacate, i.e. have it professionally cleaned, including the carpets, because the next person going in may well have an allergy to that pet.
Katie, who pays for insurance? Because we were talking about that last year. Has that changed?
No, so really tenants need to be putting that in place. If they won't put it in place and you want to keep them, you might come to some sort of deal, but it does really need to be put in place by the tenant. Can't enforce it as yet.
Can't enforce it. So really what you're saying is it's all a case-by-case basis, but you've got to document it, you've got to evidence it.
Yeah. Okay, so that leads us on to discrimination.
Discrimination, yeah. So the real drive behind the government is to create a rental sector where everyone is entitled to somewhere to live and a safe and decent home, and that each person applying for a property can get that property based on their individual basis and on affordability. We're very used to the current legislation, which means we can't discriminate on race or religion, but the new legislation means that if you have children or if your applicants are on benefits, then you've got to consider these applicants on the same merit as anyone else. So as a landlord, yes, you can still reference, and as a landlord, yes, you still have the final say, but as long as it is within the law, and if it is somebody who has children, for example, you have a legitimate reason for saying no. So it could be that it's a property with a mezzanine floor. It's not suitable for children under the age of 5, but actually it would be illegal for you to say children 16 couldn't have it, because that's just, that's just madness. So you've really got to be very, very careful about how you advertise your listing, and that you consider any application on its merit, but you can justify that going forward. Because what we're going to see is that tenants are going to be given all sorts of information by local authorities and charities, and they are really going to know their rights. And if you discriminate, they will be able to take you to the local authority or to the first tier tribunal, and you could be up for a £7,000 fine. So it is okay to look at everything on its merit, but just think about how you come to that decision. And actually, as agents, just because somebody is in receipt of benefit doesn't actually mean they're going to be a less good tenant for you. They're actually got maybe a more stable income. Somebody on a job with a job could get made redundant next week. It's as simple as that. So really, what you need to make sure is that you are looking at everything, you're covering yourself, and you're mitigating any risk going forward.
Thank you, Joy. There's been a huge change in the rent and advance and rent bidding as well. Can you talk through that?
So this is a really big change, and it's really important that landlords who are managing their own tenancies understand the next 3 points. So any rent bidding will be illegal. You will only ever be able to take 1 month's rent in advance, and it will be illegal to ask for the rent before it's due. So I'm going to give you a couple of scenarios. All of these will not be possible after the 1st of May. You're renting out a property and you've got a tenant who wants to take it. He's an applicant from overseas and he's got a great job at Awaabs, he's going to be earning loads of money, but he hasn't got his contract signed yet, and he needs to get that sorted. But he can pay you 12 months rent up front. You're not going to be able to take that going forward. The same with students who often have families who pay their money for them in advance. That is not going to be possible. You've got an amazing property in Whitney and all the applicants want to take it because we just don't have enough 2-bedroom flats. One couple say to you, if we give you an extra £50 a month for this flat, will we get it? You can't take that extra money. And the same goes with pets, so you can't take a pet premium anymore. The advertised rent is the only rent you can accept. Equally, if one of those applicants says, listen, we'll pay, you can reference us, we're happy to reference, but we're going to sweeten our offer with 6 months rent up front, you won't be able to take that either. So be really, really careful in all of those situations. So there are probably some landlords in here who have taken rent in advance for current and existing tenancies. That's fine, you don't need to repay that rent back to the tenant now, but you will not be able to ask for that rent going forward. And if you heard what I said there, it's that you can't ask for that rent. Now, if that tenant says to you, I would like to pay you my rent in 12 monthly amounts, that's okay. You are allowed to accept that. However, our advice is to be very, very careful on this point. It is in the legislation that you can accept it, but until this is tested, our advice to you is if you can avoid that in any way, please do so. Let somebody else make that mistake and end up in court. A couple of other quick points as well. Lots of landlords like to get their rent on the 1st of the month. That means changing rent payment dates, which could mean you end up taking more than 1 month's rent, so you don't do that. And also tenants often ask, well, can I just change my rent payment date to the 28th of the month because that's when I get paid, and I'll just pay that little bit to bridge the gap. Again, please don't do that anymore. That will be leading you open to taking more than 1 month's rent. It's just not worth it. So, a couple of tips on there, but I think one really big change is with regard to the tenancy move-in process. I'm going to take a sip of water before I talk about that because it's a biggie.
Yeah, that must really change how you start a tenancy and you take that rent and deposit up front.
That's right. So if you think about you moving into a brand new home and you go into your new home and you turn the tap on in the kitchen, water will run from that tap even if you haven't set up your account with Thames Water yet. That's because the government sees water as an essential right to anybody living in a home. And going forward, this is how the government see a home, that everyone has a right to a home. So thinking that through, what they're saying is that you've rented out your property, you've found your tenant and you've got them referenced. They've paid their holding deposit and they've paid their 5-week security deposit, which you have put in the scheme. At that point, it's going to change. At that point, the tenant signs the tenancy agreement, the landlord signs the tenancy agreement, and then you execute that agreement and you enter into that legally binding contract. You cannot accept or ask for that money before that tenancy agreement is signed and executed. So that means that during that pre-tenancy period, and only then can you take that first month's rent, and you run the risk of the tenant turning up on the tenancy start date, asking for that key, and because you've entered into a contract, you have to give that key, even if they haven't paid that first month's rent. And we do see that on occasion. So, for example, a tenant waiting for their deposit back from a previous tenancy to sort of bridge the gap for the first month's rent, and they just haven't got it there and then. That could happen, but they could still move in. And we see so often that once a tenant is behind with the rent, it's so difficult for them to catch up that you can end up in a spiral of arrears before we've even started on a new tenancy. So you've got to be very, very mindful, because again, tenants are going to be very aware of this new change in the law, and charities like Shelter are going to make sure that tenants know what to do if they realise that their landlord's made a mistake, and you don't want to fall foul of that.
Definitely. And rent arrears is a really big thing on everybody's mind at the moment. We at Parkers are really fortunate that we've got a very stringent process in when we find tenants, and so for a portfolio of over 400 properties, I can count on one hand how many tenants are in arrears, and it's really important as self-managing landlords you come up to that same level. There's some huge changes in this, isn't there, Joy?
That's it. And what's going to change is the timeline for dealing with rental arrears. So from the 1st of May, the notice period that you will need to give to a tenant that you're going to go to court as a claim is going to increase from 2 to 4 weeks. And the minimum level of rental arrears that your tenant needs to be in before you can issue that notice is going to increase from 2 to 3 months. So already we can see that we're looking at 4 months rental arrears before you can even start the process of getting the possession of your property back. What you also need to remember is that that minimum level of 3 months arrears needs to be at the point of serving that notice, but also on the date of the hearing. So what you might find is a tenant might pay off £200 of their 3 months arrears a couple of days before you're due to court. You're no longer at that minimum level. You've got to start the process all over again. If some of those rental arrears are due to the tenant not receiving their benefit paid for by the government, that actually doesn't account towards that 3 months either. So if they go, well, I'm in arrears because I didn't get my universal credit, that won't reach that minimum threshold. So you have to be really, really careful. And don't forget that you're going to court to get possession of your property back. You're not going to the court to get your arrears back. So you might end up getting your property back in the end, but maybe have a whole load of arrears still that need dealing with. Court times are really extending, and we're looking at a minimum of 8 to 12 months at the moment anyway. We can't see that getting any shorter in the near future. So our message to you is that you really have to make sure you've got the right tenant in place. You've got to stay on top of arrears. You've got to keep detailed notes of how you're chasing those arrears so that when you do go to court, and I hope you get in front of a judge, you can demonstrate that you've got everything in place to make that claim. And of course, it seems so obvious to us, but rent and legal protection is the only way you can deal with the rent arrears as well as all the other things I've been talking about earlier. So what I would say to you all sort of sat here today is hopefully nobody in this audience has a car without car insurance or a home without contents and buildings insurance. And really you've got to start looking at your rental properties, your portfolio, your investment income in the same way. Because, I mean, our policy is about £40 a month for rent under £2,000. If you don't have it in place, you really are now running huge risks of not getting rent at the beginning of the tenancy, of arrears throughout the tenancy. It's not just the rent arrears, it's the legal costs as well. So please make sure that you treat your portfolio income the same way as you would do car insurance or home insurance.
One thing I would say about rent and legal protection, if you are on the managed service and you have it with us, we can deal with your claim. And we've got a claim going through, only our second in the last 4 years, and I can't tell you how many hours I'm spending giving the documentation to the solicitors, proving how did I take that tenant on, how did I do their right to rent, how did I give them the gas safety in 2019. So it is super important that you have everything written down and recorded, but if you are managed, it is worth having a policy with us because we can take the pain away, and it is really quite painful.
And the other thing to mention is there are so many different policies out there. I know a lot of landlords have protection in place. Just after today, if you do one thing, it's go back and check that policy. It's going to cover you properly in the Renters' Rights Act. It's going to cover you for rent and legal costs. And if you're not sure, then have a chat with us. But yeah, just having it in place as part of your home insurance, and they give you a bit of free, landlord insurance on the side, that might not cut it in this new era.
Thank you, Joy. Okay, so the Decent Home Standard, obviously you all know about Awaabs Law. Not a huge amount has changed on that. This Awaabs Law is not part of the first phase of the Renters' Rights Act, so it's not applicable on the 1st of May, but don't be mistaken, it is coming in, and thanks to our friend ChatGPT, our tenants are more knowledgeable about mould, damp, Awaabs Law, the symptoms of mould and damp, living in a mould and dampy property, than they have ever been. So what our message for Awaabs Law is it is coming in, and if your tenants are complaining about things, you need to start looking at it in the correct time frames now. We've got a really helpful mould and damp brochure with lots of tips and hints, and the biggest thing as a landlord is your tenant education. So educating on them, well, you shouldn't be drying this much laundry, you should have your trickle vents open. Perhaps you, as a landlord, you might want to upgrade your extractor fan to a humidistat fan to help with that issue. But we have got a guide that will really help you, which we can email across to you. You can use that QR code to ask for it. So by no means is it going away, it is coming, and you do need to be ready for it. And that leads me on to compliance, liability and compliance. I could stand here and talk to you for hours about the liability of the landlord and all of the compliance, the 179 regulations you have to comply with. But my basic message is that not a lot has changed since I stood here last year. You still need your gas safeties, your EPCs, your EICRs, your smoke alarms, carbon alarms, right to rent. And the most important part of all of that is your documentation. When did you have it done? How did you give it to your tenant? Did you do it in the right way, by email or by post? And have you done that every time you've had a new certificate issued? It is all you need to know as a landlord. It is the biggest part of how you rent a property out. And when the private rented sector database comes in, that's going to be the biggest thing that's going to get you fined. So when I'm talking to new landlords, I explain the PRS database a bit like when you go to buy a car. When you go to buy a car now, you can type into the government website the registration number, and it will tell you whether it's insured, taxed and MOT'd. The PRS database is the home version of that. Tenants will be able to put the address in and find out, has the gas safety been kept up to date, the EICR, the EPC, and if you haven't kept up to date with that, it will be a very easy click of a button and you will be dobbed into the local council, and the fines start at £7,000 and they go up to £50,000. So it really, really isn't worth not doing correctly.
Big intake of breath, because this is the change. Being a landlord isn't a hobby anymore. It is a serious business, and government is absolutely focused on regulating the private rented sector. So in order to do this, they are changing things. I think this has been a problem in the past. They've had a lot of this legislation already. It's just not been enforced. And landlords have been getting away with it. Some landlords are terrible out there. They bend every rule, and that has impacted on the entire sector. Because you're all good landlords, you're here to learn. There are so many landlords out there who don't do it properly. And this is what, quite rightly, the government wants to change. So it's sort of a two-pronged approach. Tenants are going to be given a lot more information. They are going to be fed through social media, through the charities. They will know their rights. They're going to be on ChatGPT non-stop, day and night, working out what they're doing. They're going to think, yes, this is my right, and now I know what to do about it. It's going to be enforced as well through local authorities, so tenants can report to local authorities. Local authorities can self-regulate their areas as well. Tenants will be able to report to local authorities. They will also be able to go and use the first tier tribunal. And what that means is that the first tier tribunal can look at anything that's happened in the last 24 months that a tenant has reported to them. So if, for example, 18 months ago, you forgot to send your gas safety to your tenant, you had it done, but you forgot to send it to them, that's an infringement of the law. The tenant could go, hold on a minute, I thought I saw, oh yeah, and then go to the first tier tribunal. The first tier tribunal can award up to 24 months worth of rent back to that tenant. So that's going to increase from 12 to 24 months. And the tenants have an extra 12 months to report that. They'll also have banning orders, and of course the Ombudsman is going to be in place soon. So you've just got to make sure that you are watertight beyond doubt.
No, I don't think so.
It's the right thing, and so long as you do it right, you're in the best place. But I think there's a lot of self-managing landlords out there today, and I think we might have the solution for that.
We certainly do. So at the beginning of the Renters' Rights Act, and last year I touched upon it, we brought in a service called the Rent Receipt Plus, and it bridges the gap between a self-managing landlord and the fully managed experience. And so what you have with Rent Receipt Plus is we help you with the compliance. So we take that liability from you. It's our responsibility to tell you, dear Mr. Landlord, did you know in 60 days' time your gas safety is due? Would you like to arrange it with your contractor? Oh no, he's on holiday, that's fine. We will arrange it with our contractor for you. We will issue it to the tenant correctly and we will evidence that issuing. So it takes away that liability of the compliance, but you can still use your trusted contractors who will go out to your emergencies, who might have been your gas engineer for 20 years, but you know you've got us to fall back on to remind you of those dates, and most importantly, issue those certificates correctly and evidence them to the tenants. The other benefits of the service are that you will benefit from the out-of-hours triage service. So all of our tenants love to phone us about 8 o'clock on Friday night and let me know that it did happen on Wednesday, but they've waited until now to tell me their boiler's broken and they've got no heating, no hot water, it's -5 outside and I've got 2 under 2 with me. So we will cover all of that as well as holiday cover. So you can finally go on holiday as a self-managing landlord and not wake up at midnight and think, my gas safety is due tomorrow, I haven't dealt with it. We will deal with all of the maintenance, anything that comes in while you're on holiday. And the most important part of that is that we will help you with the rent reviews. So these market rent reports that we're talking about, the evidence that you're being a fair landlord, we can help you with and we will do your rent review. So there'll be no wishy-washy of issuing section 13 and you not doing it the correct way and not having that evidence. That is all part of that service. So whilst Brendan takes a breath to come up and present to you, that is the QR code that he spoke about earlier on today. It's also on the back of your brochure. So if there is anything you'd like to talk to us about, any compliance, the Rent Receipt Plus service, anything like that, you can use that QR code and book in a free 15-minute talk with our qualified team. Thank you, Brendan.
Thank you, Post. Goodness me. Some scary stuff there. Obviously, it takes a lot of work to put on an event like this, and there's quite a lot of work afterwards. So please do book a chat, but don't expect it to be tomorrow, please. And if it is urgent, then mark it urgent, and we'll try and get back to you rather sooner. But we'll probably be getting back to people next week on most of these things. So we've spoken about what's going to happen on the 1st of May. We know what's coming then, but we know that's not all of it. What are the next steps? So phase 2, we'll start with the private rental sector database you've just heard about. We expect that to be back end of this year, more realistically, possibly early next year. These things rarely run to time, as we know, but it'll be rolled out regionally. And we'll keep you updated. We've got your details, so we'll let you know what's happening and when. Naturally, there will be a cost, an annual cost for that. We don't yet know how much. But if you've got 30 properties, yep, you're going to have to register 30 properties. You're in there 30 times. Stage 2, which naturally follows on from that, will be the ombudsman for landlords, for those that manage their properties themselves. Agents have had to do this for ages, but a tenant needs, or it's been deemed that they need someone to be able to refer a complaint to if the landlord cannot resolve that and there's no agents involved. And so landlords will have to join an ombudsman scheme. There'll be a cost for that. We don't know how much, nor do we know who the ombudsman will be at this stage, but that is likely to come in about 2028 once the database is complete. And then phase 3, further down the line, we'll be talking about the new Decent Home Standard, probably incorporating Awaabs Law, which is already in the social housing sector, and good old minimum energy efficiency standards. And I said that right. I will come back to that in a moment. So, let's move on from the Renters' Rights Act for a moment. Making tax digital. Not my specialist subject, nor do I expect to talk very much about it. But you need to be aware of this because it's already in. My birthday present, yes, that is my birthday, 6th of April. If your self-employed income is £50,000 or greater, including your rental income, so rental income plus any self-employed income, you need to now report quarterly to Revenue and Customs using specialist software capturing all your income and expense. The QR code will take you to the detailed guidance. It's pretty dry, but you're going to have to do that because actually in subsequent years that threshold is reducing. So as you can see there, £30,000 next year and £20,000 the year after. When you look at what the average rents are in West Oxfordshire, even if you have no additional self-employed income, that's going to drag most landlords across the threshold within a couple of years. Practical advice we can give you: have a separate bank account for any of your rental income. Do speak to your accountant and find out how to deal with this, or if you're one of our clients and you're managed, then we can offer you a solution for about £20 a month to make this go away. But it's yet another thing that landlords are expected to now deal with. Minimum energy efficiency standards. Where do I even begin with this complete disaster. So the Department for Community Housing and Local Government have confirmed that by the 21st, sorry, they confirmed on the 21st of January that by the 1st of October 2030, all private rental sector properties will need to be a minimum of a grade C. Now that sounds simple, but it's not, and I'm going to tell you why. They also said that the cost cap, so the costs that landlords have to incur before they can seek an exemption, will be rising to £10,000. You're going to do £10,000 worth of work before you can say, hold on a minute, I'm still not on a C, please can I have an exemption? But this is where it gets really crazy. The standards for EPCs are being completely rewritten. And just a few weeks ago, that rewrite was delayed until 2027. So can we reasonably expect that that deadline might be pushed to the right again for the 30th time? I don't know, quite possibly. Let's be honest, we're going to have an election between now and then. That may well change things. Will there be enough contractors to do all this work in time? I don't know. But the draft of the new regulations that I've already seen, if you've got a brand new property today, EPC grade A, if it's just got a gas boiler, but it's nice windows, well insulated, all the rest of it, that will not be a minimum of a C under the proposed new regulations, because under the new regulations you will have to have something like an air source heat pump or solar to qualify. I know, right? But we do know that the existing certificates will still be valid for 10 years. So when we know what the deadlines are, and if your property is a C but doesn't have solar panels, guess what? Spend £96 or whatever it is to get an EPC, and that will get you across the line for another 10 years. All I'm saying is, don't rush to do anything today, but if you think that your properties are going to fall foul of this, start squirreling away a bit of money and keep an eye on it, and we will keep you informed. Likewise, if you have a tenant in receipt of any sort of allowance or benefits, then there will almost certainly be grants available that you can claim to have this work done at a significant discount. So again, something to keep an eye on. Watch this space, be aware, start to prepare, but don't do anything at this stage, because guess what? It's probably going to change again. Right, very quickly, what's going on in the local lettings market? Well, it probably doesn't come as a great surprise that the private rental sector is shrinking somewhat because of all these regulations that landlords are facing. Yeah, so the total value of housing in the UK rose by 3.8% last year, but the PRS, the private rental sector, fell by 5.1%. And that represents 3 consecutive years of decline. Now, just because, and that's £79 billion worth of housing that has disappeared from the private rental sector since 2022. But a landlord selling doesn't always equate to a net loss to the private rental sector, because actually 30% purchased by the landlords, and that's something that we deal with regularly. Landlords selling, landlords buying, match the two together, problem solved, particularly under the new Section 8 regulations. But another third are bought by first-time buyers, 29% by other residential buyers, but we are seeing that gradual diminishing of houses in the private rental sector. So what's happening in our local market? Well, the southeast, the blue line, compared to the UK average, the black line, is a little bit more extreme in terms of the changes, the rise and falls over the last 12 months, but rents are broadly growing. They are seasonal, but they are continuing to go up. And affordability, certainly locally, is actually better this year than it was last year, because wages have been growing faster than rents over the last 12 months. When we look at what's happening with houses in West Oxfordshire, the yellow, yellow is southeast, the blue is West Oxfordshire, our rents are fairly tightly compressed, and that is because we have a rather different mix of housing stock here in West Oxfordshire. There are far fewer flats, granted a lot of them are within the private rental sector. There's virtually nothing there below £1,000. Equally, very little above £2,000. So nearly all of the housing stock within West Oxfordshire sits between £1,000 and £2,000 per calendar month. It is much more compressed than the regional market. in recent times, over the last few months, we have seen far fewer properties available to rent, but we've also seen some changes in the sorts of applicants we're seeing come to us. Now, that is probably because some people are still using Section 21 notices to evict tenants that they're not sure about and they don't necessarily want in their properties ahead of this new Renters' Rights Act regime. But also, what will happen going forwards? Don't really know. I expect rents will continue to go up, but probably rather more slowly because we have seen affordability improve and West Oxfordshire is a strong market. I also expect, as I mentioned earlier, that we'll see average tenancy lengths increase because that was seen in Scotland under similar regulations. What's going on in the sales market? Well, the orange elephant in the room has rather changed things over the past few weeks. Before the war with Iran, the market was looking pretty good, actually. We were seeing really strong levels of inquiries. The highest number of properties came to the market, or the highest number of properties available to buy for 7 years in the UK property market. There was a lot of stock for sale. Interest rates were going down, and the idea was, or the perception was, that mortgage rates would continue to fall. All of that has changed. And I think it was yesterday's headline. You know, the market is now seeing a little bit more turmoil, not surprisingly. What I was staggered to read in this morning's industry press was that the average life of a mortgage product is now just 8 days. That is the lowest it has ever been. And to put that into context, remember Liz Truss's magic mini budget? The average mortgage lifespan then was 15 days. We're now on 8. And that is what is affecting people's ability to buy houses. Now, West Oxfordshire, we have a higher proportion of cash buyers. They clearly are fortunate enough not to be affected by this, but we are seeing a very slow market in flats and in properties above £600,000. It has quietened down. 3-bedroom houses in Witney, absolutely on the sweet spot. There's still strong demand there, and we're seeing strong levels of inquiries. But the market has slowed as a result of what is going on. But the good news is the West Oxfordshire market has been rather more resilient. And of course, this data here won't reflect what's been going on in Iran. This is land registry data, but it is bang up to date. But of course, anything that comes from the land registry is de facto 4 months out of date, so it takes that long to buy a house. But you'll see here, West Oxfordshire is up, certainly much more strongly than the wider southeast, and more strong than the UK, or England and Wales as a whole. I expect that to continue to be the case. And the reason is twofold. One, we're still seeing net migration into West Oxfordshire. It's a lovely place to live and work. But also, we're not building enough houses to meet that demand. The average number of properties built in West Oxfordshire per annum over the last 5 years is just under 550, and the demand is in excess of 1,000. And so that is going to at least hold up that middle market, that core market I was talking about, where we're still seeing strong demand and strong transaction levels. Right, we are very nearly there, you'll be pleased to hear. Just to remind you, your one job was to make sure that you don't leave having not asked questions that you want the answers to today. So we'll go into a bit of a Q&A session in just a moment. But our job is to give you the information that you need to make informed decisions and to keep you updated. And I hope we've done that for you today. If any of this makes you uneasy, then as Katie said, there's an easy solution. Transfer liability to your agent. I can't believe I'm saying that, but we can make a lot of this go away. We're not infallible, but if we've caused the problem, then we will fix it. We are about to go into a Q&A for things that are pertinent to what we've been talking about, but if you've got individual questions, then it's not just us you can talk to at the end of this. We've got the wider Parkers team, and they'll all be wearing name badges so you can identify them. We've also got Nikki and Deba from Parker Bullen. They're waving around the corner there, but they will be out the back with their banner. They're solicitors who can deal with all of your legal property matters, and I'm certain we'll be busy dealing with Section 8 notices from the 1st of May going forwards. Chris, See, still, he's hiding at the back. Chris from Van Mark Financial Services specialises in buy-to-let mortgages, but can deal with any mortgages and equity release. He'll be out the back as well to talk to you. And we're also very fortunate to have Phil Meadows and Paul Lancaster from West Oxfordshire District Council. Again, back, they are the lead for housing enforcement and landlord and tenant issues. And so they will be around and can answer any questions you have from their perspective as well. So it's really good to see them here tonight as well. So I'm just going to grab the microphone so I can stop shouting. And who is going to be brave and ask the first question?
Oh, lady in the middle.
So after the 1st of May, and if you want to make any changes to your periodic tenancy, because your tenants won't be changing because of the dates that are going on at the moment, you want to make a change, i.e. for pets, can you legally issue an addendum to the current periodic tenancy agreement?
Yeah, exactly that. That would be the best way to do it, is issue your addendum to show the change that you've made.
Perfect, thank you.
Let us in gently there. Yes, please.
If you serve a Section 13 and you then negotiate with your tenant to take a lesser increase, and you reissue the Section 13, so you've got it legally written down, do you have to give them an extra 2 months before that increase can take place?
We'd only reissue it if you did have a really difficult tenant. So if you've agreed, an email covering that agreement would be sufficient.
Okay.
But in the eyes of the law, if you were to go to court, they're likely to say 2 months from the issue of the Section 13.
So the second one?
The second one, yeah, because your second one will supersede your first one.
Yeah.
Thank you. Yes.
Sorry, it's 2 really quick questions about pets. Can you
You're
ever,
again then.
can you ever reasonably withdraw that permission that you gave pets? If, for example, they said it was going to be a property, but they actually brought another dog or something. And then secondly, you mentioned that if they get pets, you can change it to say, the agreement to say, you need to get it professionally cleaned, for example. But I thought under the Tenant Fees Act, you can't ask tenants to get it professionally cleaned.
You can for pets. So pets are a very different thing because people do have allergies to that, so you can specify, I've given you permission for a pet on the basis that you will professionally clean the property, including the carpets, and give the invoice for that. I don't think you'll be able to withdraw your permission for a pet. That's probably more a Parker Bullen question, and that's going to be tested in court really. So yeah, that's a tricky one. Once you've given permission, I understand they've got a different pet to what you've had, and that's where your management visits come in. And we would be saying to landlords, you have to do management visits twice a year, make sure you've got the correct pets in there, the right tenants, and then you'd have to go to your solicitor about that one and probably go to court, I would expect.
Yeah, I mean, technically they'll be in breach of the tenancy, but and you can argue a Section 8 on that. That's going to be a discretionary ground, and unless they've moved in half of Cotswold Wildlife Park, the judge is unlikely to say swing your hook.
Okay, I've got 2 questions. One's easy.
I'll
About deposits. Is there an effect on deposits? That's an easy question.
No.
Second question is a bit more complicated. We've got a tenant who's from the US, has paid in advance. Tenancy is renewed in September. What's the position there in terms of that lady?
Yeah, so any rent that you've taken up to now, you can retain that rent, you don't need to repay it, and then it's up to you. Do you re-reference your tenant now they're here in the UK? They might well pass referencing, and if you can, then you've got that security, or you just take the risk and they pay monthly. That's it. They could offer you the money, you could take it, and as I said earlier, you run the risk of.
So is the tenancy void then from first?
Tenancy is not void, nothing, no, the tenancy will still stand.
So the tenancy stands until it's
The
finished?
tenancy will stand, that end date has gone, and that tenancy stands until either party give notice.
Okay. And the deposits, what's the position on that?
No change on deposits, deposits stay the same.
Okay, thank you.
5 weeks.
Yep.
solid oak, solid wooden floors throughout, and having a cat there would be a very serious risk. Would that be acceptable? I mean, as it happens, I am also allergic to cats. But
You've got to be prepared to justify that ultimately in court. So, you know, if you think that's going to stand up, then yes.
okay.
I would argue on that one that having solid wooden floor and having any cat or dog will have a detrimental effect to your property. They're going to scratch it, that's the way pets live. But your allergy will come into that as well.
Yeah, I was going on from allergies. How would you prove that you have an allergy?
That needs to be documented for someone from the doctors.
So you have to go
You would need to be able to prove it.
Yes.
Absolutely. A few from the back?
Yeah, thanks.
Oh, okay, go on.
What about listed buildings? I've got a listed building which I can't put in double glazed plastic windows, I can't put on solar panels. Stand with regard to
Yeah, that's an energy efficiency standards question. So the way the law stands at the moment is that you still have to have an EPC if you're going to rent it, and it has to meet the minimum standards. We don't have the regulations for what the new standards will be, but if it's an ER above at the moment, then you're fine and say get a new one reissued in advance. And as I said earlier, just watch this space. You know, it's changed that many times, and I have no doubt it will change in the future as well. But have to have a chat afterwards. Yeah. Yes. Then.
Where is the first tier tribunals held? Is it all emailing? Is it local council, or is it where? Who are you talking to? Is it council people?
Yeah, it's local county courts. Yes.
Yeah, just wondering, you mentioned the rent receipt plus. Is there a standard fee for that? Or is it dependent on the size of property?
It's dependent on the amount of properties that you have and the service that you require, but I'm happy to have a chat at the end. All of our fees are published on our website, but we do tailor-make each service for each landlord dependent on your requirements. Yeah.
One more question. Do you offer a separate Section 13 service as opposed to going all in with the C+? Like you do a tenancy service?
Yeah, it's likely to be something that we will offer, probably not in the very initial stages because we're going to be a bit bombarded, and I've only got the team that I've got and 400 managed properties, but it's likely to be something that we can offer further down the line.
Conscious of time, we'll take two more questions, but we can then break out and do questions again. So
Did you tax?
no, not your question. Go on.
Does pensions come into that, or it's the amount you see, full on?
It is your total income, but it is, you need to get into your accountant with exactly what is covered. It's not an agency question, it's an accountancy question, I'm afraid. So it's not my specialist area. But all the regulations are on that QR code that I put in the presentation. It's going to be lucky.
So if you have the full managed service from yourself, perish the thought something later on, who takes the liability?
Us, assuming that we have made the mistake. If we said that you need to do something and you've not done it, then that wouldn't be our liability. But if we make a mistake, then we absolutely hold the liability. Brilliant. Please come and join us for a drink. Thank you.